Insane National Historic Preservation Act, NHPA, Part 2. Best Environmental Law Review and FEMA. FEMA. Federal Emergency Management Agency, FEMA's unified mission is to help our states, local, and tribal partners prepare for and respond to disasters before, after, and during events. For a project to be eligible for Federal Emergency Management Agency, FEMA, grant funding the project must be the result of a presidentially declared disaster, and the action must be the legal responsibility of the eligible applicant. FEMA's mission is to help people before, during, and after disasters. FEMA's actions make communities more resilient to natural disasters through improved management plans and hazard mitigation actions that foster improved health and safety, as well as prolong life. FEMA helps communities within disaster events so they may get back to pre-disaster situations or better with actions that are fully compliant with mitigated impacts to environmental or historic resources. Hazard mitigation plans for communities are necessary for local communities to improve their actions and help them withstand future disasters. Hazard mitigation actions improve the project to mitigate repeated disaster impacts from occurring. The federal government avoids wasting funds repairing back to pre-disaster condition if the issue is going to repeatedly reoccur. Therefore, we improve actions and apply hazard mitigation actions when needed to ensure our use of funds can last through future disasters and not require repeated repairs. We mitigate future disaster impacts preventatively whenever necessary. Be sure to slow the video speed settings if you want to watch the video in a slower pace. FEMA NHPA compliance. FEMA Environmental Historic Preservation, NHPA, serves the United States during times of natural disasters to ensure all federal grant dollars are in compliance with all statutes, regulations, executive orders, policies, and guidelines. FEMA Environmental Historic Preservation, NHPA, coordinates with regulators to ensure compliance of all of our projects within 3 programs: hazard mitigation, HM, public assistance, PA, and individual assistance, IA. The federal agency completes compliance reviews for all laws, for example, not just NHPA, but also makes determinations for CWA, CAA, ESA, RCRA, FWCA, MSA, CZMA, CBRA, NHPA, EO 11988 Floodplain Management, EO 11990 Protection of Wetlands, EO 12988 Civil Justice Reform, Environmental Justice, as well as many others. Our compliance reviews for FEMA require understanding and implementation of all of these and more. As a reviewer, we all must normally have an applicable bachelor's degree to qualify for an employment position in the environmental and historic preservation. I am a rare find because I have a master's degree that is specifically from a top environmental law school in the nation, Vermont Law School, where I graduated among the top of my class at above 3.678 cum GPA. Most individuals have general master's degrees and not one specific to all the statutes and executive orders. Our compliance reviews must apply to every project. This BLS degree includes coursework on all statutes and EOs listed, including NHPA. FEMA Environmental Historic Preservation, NHPA, program performs compliance reviews for all FEMA disaster grants under the Stafford Act. FEMA NHPA provides technical assistance on the formulation of projects looking at hazard mitigation plans to help communities approach challenges and avoid compliance issues. FEMA looks to make disaster prevention, recovery, and response actions as smooth and streamlined as possible while also mitigating future disaster impacts by implementing improvements anytime necessary. Federal Emergency Management Agency, FEMA, grants include FEMA NHPA project reviews for different categories of projects. Watch my other videos for more information on these categories of work. Smash the like button for the YouTube algorithm. NHPA, United States Statute, National Historic Preservation Act, NHPA, was enacted in 1966 to preserve historical and cultural heritage by recognizing and protecting significant historical sites, buildings, structures, and objects throughout the nation. The National Historic Preservation Act, NHPA, was created in response to concerns about the rapid loss of historic buildings and cultural sites due to urban renewal, transportation projects, and other development activities. NHPA exemplifies the importance of identifying, protecting, and enhancing the nation's historic and cultural heritage for the benefit of present and future generations. NHPA is intended to avoid, minimize, or mitigate adverse impacts on historic resources. Undertakings, by definition, include effects on historic properties of any project or activity that they carry out, assist, fund, permit, license, or approve. For example, new construction, alterations, renovations, grant dollar approvals, and other actions may be considered an undertaking. NHPA encourages the development of comprehensive preservation plans at the federal, state, and local levels to guide historic preservation efforts and identify priorities for historic resource protection and stewardship. The National Historic Preservation Act, NHPA, provides a framework for agencies to follow for considering the potential effects of their activities on historic culturally significant resources through actions focused on preservation. The National Historic Preservation Act provides an approach to how federal agencies should approach undertakings with respect to historic preservation through consideration of impacts prior to taking actions. The undertaking or actions performed by the federal agency must not have an adverse effect on historic properties. Consultations must occur and actions to minimize, mitigate, and avoid adverse effects. The regulating authority SHPO, THPO, and HPO review consultations completed by agencies and approve of actions taken to minimize, mitigate, and avoid adverse effects or deny approving of projects because of the adverse impacts they cause. Agencies cannot fund projects that are not in compliance with NHPA because if they do, they break the law and are liable for their actions. Redevelopment initiatives can no longer demolish historic and culturally listed sites without considering the impacts of this decision. There is a movement throughout the United States to maintain historic, culturally significant structures, buildings, objects, and sites designated to be protected by law. Agencies must now protect historic properties and consider the irreversible consequences of our actions on historically and culturally significant resources. The National Historic Preservation Act, NHPA, creates a process for considering the nature of effects on historically significant resources. Other cultural resource laws that foster historic preservation actions include the Antiquities Act of 1906 and the Historic Sites Act of 1935. The National Historic Preservation Act also established a fund called the Historic Preservation Fund to provide financial assistance for historic preservation projects and initiatives at the federal, state, and local levels. Level up your life. Follow us on Medium to unlock our secrets. Subscribe to us on YouTube. Personal experience. Interestingly, I managed compliance actions for NHPA for federal FEMA DHS projects specifically in Saipan, Guam, Tinian Island, Rhode Island, California, Hawaii, North Carolina, Oklahoma, Louisiana, Florida, as well as Region 4, 6, 7, and 9. All my compliance reviews include NHPA determinations for Tier 1 and/or Tier 2 projects. Tier 2 projects require an SLI qualified individual to sign off on the determinations, but Tier 1 determinations do not require an SLI qualified individual to sign off on the determination based on FEMA's Memorandum of Agreement with the Historic Preservation Offices in accordance with NHPA. I completed reviews for NHPA and made recommendations to stakeholders to preserve historic characteristics of listed places where upper management in our Environmental Historic Preservation Division would confirm and approve of determinations, project actions to be taken prior to their actions being approved, grant dollars being provided, and actions being completed by project candidates. SOI qualified individuals complete the consultation processes. Non-SOI qualified individuals like me apply Tier 1 and Tier 2 allowances to projects or make no-effect determinations, while SOI qualified individuals sign off on Tier 2 determinations and complete consultation processes for more complex projects to ensure compliance actions are sufficient for NHPA. Even if a reviewer completes some NHPA review, there are always managers approving of final determination for all aspects of every determination for each project. This means reviewers are just the first set of eyes making detailed reviews for a project, while managers confirm all determinations well before project actions are approved by FEMA or a regulator. If the applicant takes actions before FEMA completes their compliance review, they risk approval of funding for their project. Yes, candidates sometimes fail to notify us of their actions before they do them. If actions are not in accordance with statutes or legal requirements, the candidate risks not receiving disaster grant dollars provided by FEMA. If they cannot perform their project actions in accordance with all environmental and historic preservation statutes, regulations, policies, executive orders, EO, guidances, or other requirements. As an environmental and historic preservation environmental protection specialist, we ensure all FEMA DHS projects are in accordance with all environmental and historic preservation statutes, regulations, policies, executive orders, guidances, or requirements. This means the federal agency must identify historic properties that may be affected by the proposed project and assess adverse effects of the actions, then implement mitigation, minimization, and/or avoidance actions prior to carrying out any action that impacts the historic property. The federal agency must obtain concurrence from the SHPO, THPO, and/or HPO regulator to ensure actions are sufficient to preserve and not cause an effect to the significant characteristics of the historic property. The federal agency and applicants for FEMA grants must consult with the regulator to gain concurrence for actions pertaining to historic properties and ensure adverse effects are sufficiently mitigated, minimized, and avoided to ensure grant funding processes for projects in a positive, successful way. Smash the like button for the YouTube algorithm. NHPA compliance reviews. If a federal project has potential to affect historic properties, NHPA Section 106 applies and compliance actions must occur. If no effect exists, Section 106 does not apply and further compliance actions or review is not required based on the determination of no effect to historic properties. Once an effect on historic properties is determined to exist, the agency must complete actions to mitigate, minimize, and/or avoid adverse effects to historic properties. For the FEMA review process, the project review process is a streamlined process. The reviewer assesses whether the project scope and details include Tier 1 and/or Tier 2 applicable actions. A project may have multiple actions that are individually either Tier 1 or Tier 2. If any of the project details are Tier 2 applicable actions, for FEMA actions, presently the regulator requires the final determination decisions to be approved by an SIO qualified individual. The SIO qualified individual must have specific experience and/or qualifications, i.e. applicable master's degree completion to be qualified to be an approved SIO qualified individual. The SIO qualified individual must sign off on the final NHPA designations for NHPA Tier 2 projects, while non-SIO qualified employee can perform NHPA reviews for all projects. The SOI qualified individual must sign off on the final determinations for Tier 2 projects. This may vary state to state and disaster to disaster because for compliance FEMA can always choose to implement a stricter requirement than required. FEMA always wants to have a review process streamlined for efficient and effective compliance actions. Thus, stricter or slightly different implementation methods may vary with location. FEMA must only implement the approved process, but can always choose stricter actions or oversight than approved. Even when compliance reviews are completed by lower-level reviewers, they are still always approved and reviewed by managers who sign off on all determinations. In this way, FEMA has checks and balances that foster the most effective and efficient outcomes. Smash the like button for the YouTube algorithm. Managers who rank below the EHAD reviews projects as well to ensure projects are in compliance. The Environmental and Historic Preservation Department Environmental Historic Preservation Advisor, EHAD, oversees all decisions and determinations by reviewers and their managers. By the end of the compliance review process, multiple individuals review and approve of the final decision to ensure decisions are in accordance with all environmental and historic preservation statutes, regulations, policies, executive orders, guidances, etc. This methodology mitigates errors and fosters coordinated best actions to ensure compliance for each project. Once the determination is made, Tier 1 actions under the FEMA Programmatic Agreement allow for exceptions from the consultation process. The Tier 2 determinations require the SIO qualified individual to consult and draft a formal consultation report that is approved by the regulator and includes mitigation, minimization, and avoidance treatment measures to be taken to ensure no significant adverse effect to historic properties. Consultations often take months to complete start to finish from drafting to gaining concurrence. If either party is not experienced or the scope of the project is complex, the consultation may take years to complete and gain regulatory approval. Once the agency submits the consultation to the regulator to review, the clock starts for a 30-calendar-day review process for the regulator to review and respond. Consultations require a 30-day public comment period and involve the public prior to final approval decisions by the regulator. The agency and regulator will continue to coordinate until the drafted consultation is approvable or denied based on no feasible sufficient treatment measures being approvable to prevent significant adverse effects to historic properties. Once the consultation process is completed and approved treatment measures are determined, the project at that time may implement actions in accordance with the consultation agreement. Proper implementation of the consultation actions may also take months or years to ensure all treatment measures are properly implemented. The agency coordinates with the regulator throughout the consultation, but also throughout the implementation of the consultation actions agreed upon. The regulator completes site visits to ensure the consultation agreed upon actions are completed in compliance with NHPA throughout the project implementation. The project, by the end, should have no significant adverse effect, or the project consultation drafted would be denied by the regulator. The agency must create a consultation that provides sufficient actions to mitigate, avoid, and minimize effects to historic properties to ensure no significant adverse effect exists. Otherwise, the agency risks being denied approval to complete the project due to unlawful irreversible impacts to historic properties in breach of NHPA. Tribal consultations. There is a nation-to-nation relationship between the U.S. government and federally recognized tribes that honor the sovereignty of tribal nations. Consultation and collaboration with tribal governments occur just as they do for SHPO and HPO, in accordance with NHPA. Smash the like button for the YouTube algorithm. NHPA Section 106 Process. NHPA Section 106 process requires federal agencies to enter a four-step review process to consider the effects of its actions on historic properties. For example, the federal agency, FEMA, must take into account the effects of actions or undertakings on historic properties and afford the Advisory Council on Historic Preservation, ACHP, a reasonable opportunity to comment on FEMA actions as outlined in 36 CFR Part 800. Program alternatives can improve the effectiveness and efficiency of Section 106 reviews and streamline routine interactions while focusing effort on the more complex projects or historic properties most important to communities. They can also help interpret and raise awareness about important historic properties and strengthen the state, tribal, and local partnerships critical to their care. The 5 program alternatives listed in 36 CFR Section 800.14 are: Programmatic agreements. Exempted categories. Standard treatments. Program comments. Alternate procedures. A program alternative may aid agencies in accomplishing their missions more effectively or efficiently. When an agency carries out certain undertakings repeatedly, effects or treatment measures can be consistently applied for certain actions instead of reviewing each individually. Tailoring a consistent four-step process provides increased specificity, reduce delays, or allow applicants to take on more responsibility for projects. To identify program alternatives, a consultation process must occur to determine the best procedure for a certain undertaking or group of undertakings. Proposals for program alternatives are refined through feedback from consulting parties and the public, reaction from other involved federal agencies, and ACHP review processes. This all takes time to finalize and gain concurrence on. The overall outcome is to protect historic properties while fostering improved actions for a certain undertaking or group of undertakings. Smash the like button for the YouTube algorithm. NHPA Programmatic Agreement Allowances. There are allowances in our programmatic agreements, but they must meet specific conditions in order to avoid full consultation processes. Just like other allowances listed within the programmatic agreement, FEMA can apply the allowances and conditional mitigative actions, if any are described, that require implementation. If FEMA does not implement conditions listed, the project may require a full consultation with the regulator. Subscribe by clicking on my on-screen photo. We will help you level up your successes and foster the best outcomes in life. FEMA Section 106 Process. FEMA demonstrates our compliance with NHPA first and foremost with the Section 106 process, which does not demand a specific outcome. Instead, National Historic Preservation Act requires federal agencies to consider effects that their undertakings may have on historic properties. Section 106 outlines the steps in a process that, when thoughtfully and meaningfully followed, fulfills that requirement. Here we will clarify the four major steps in the Section 106 process that we must implement and document sufficiently to document compliance with the National Historic Preservation Act, NHPA. Within Step 1, we initiate the process by establishing or defining the undertaking. We establish the action or project being funded, clarify the scope of work, and determine any potential to affect historic properties. Within Step 1, Step 2, we identify and evaluate whether there are any historic properties at or near the project location that could be affected by the undertaking. We assess effects on historic properties. We address the potential for adverse effects to those historic properties and decide what type of effect the undertaking will have. We identify whether the project will negatively impact a historic property. Ideally, we are able to say with good confidence that an undertaking will have no effect on historic properties or no foreseeable adverse effect on historic properties. This finding is documented, and the Section 106 process typically ends when it is determined there is no effect. When an undertaking is found to have the potential for adverse effects, we move on to the final steps of the Section 106 process. Step 4 is to resolve adverse effects within a consultation process, working with the Historic Preservation Officer to agree upon approved minimization, mitigation, and/or avoidance actions. The project's scope of work may be redesigned to avoid causing the adverse effect or complete abandonment of the project. A project may need to be abandoned if approvable treatment measures are not viable. FEMA does not normally abandon projects because there is usually an emergency disaster-related need for the project. Instead, FEMA closely consults with the regulator to fulfill this need while preserving historic properties in compliance with NHPA. Minimization can include the redesign of a project to reduce the severity of adverse effects. Mitigation actions occur when the adverse effect can't be avoided or minimized. Instead, creative measures are taken to offset adverse effects. Every dollar spent by FEMA must comply with NHPA, so project scope of works do often have no effect on historic properties. Potential to adversely affect historic properties are not common and require consultations with regulators to gain approval for projects with implementation of approved minimization, avoidance, and mitigation actions. Feel free to check out Level Up with Alyssa Mahan YouTube channel to level up your life in a personalized way. See you there. National Register of Historic Places or National Historic Landmark Lists. Often the programmatic agreements describes review exceptions for properties under 45 years old. Regardless of the age of the property, we must ensure the property is not designated as historically significant by being listed on the National Register of Historic Places or National Historic Landmark Lists. A historic property, for example, may have a NHPA National Historic Landmark designation because it is associated with a famous historic person. A historic property can be a building, district, object, site, or structure which is listed on the National Register of Historic Places or has been determined eligible for listing on the National Register of Historic Places. Sites may be eligible for listing or listed on the National Register of Historic Places and require more detailed compliance actions. The first thing we may assess when determining eligibility for becoming listed is the age of the site being over 45 years old. Listed sites can be new construction and not over 45 years old. But if a site is over 45 years old, there becomes potential for historical significant characteristics for a structure, building, site, or object that we may wish to preserve the integrity of. Being old doesn't automatically make a property historic, but it's part of what we consider as we make our initial review of properties. Comment Level Up to show you are ready to level up and watch this video to the end. Work in cemeteries. Cemeteries are sensitive areas in many ways. Work within cemeteries should avoid removing root balls as burials may become pulled up out of the ground with the root ball when it is removed, and we wish to not disturb burial sites. General debris removal in cemeteries can cause more damage to gravestones, stone walls, gates, or buildings in the cemetery than the original disaster caused if actions are not taken with care to proactively preserve and prevent damages to the sites. Document. Document all before, during, and after actions are taken. In cemeteries, we may choose to tip root balls back in place to bring it back to its pre-disaster position and avoid or minimize ground disturbances. Work in cemeteries should avoid using heavy machinery within the boundaries of the cemetery if at all possible, and also keep this equipment on paved surfaces because heavy equipment can damage gravestones or cause further ground disturbance. Whenever possible, try to use hand tools for debris removal actions and avoid staging debris on unpaved surfaces within the cemetery because this could cause further ground disturbance or damage to the cemetery itself. If a cemetery is over 45 years of age, definitely take photos and document all damages and actions taken. It is very important that repairs are done correctly by trained individuals to ensure actions are completed as planned and do not cause more damage to the site. When actions are done incorrectly or inappropriate materials are used to repair gravestones, further unforeseen damages to the stones may be caused. Certain materials should be used for different types of stones, so definitely be sure to coordinate with the regulator SHPO, THPO, and HPO directly to ensure your actions are taken in a manner that avoids damaging the site and stones. Whenever possible, ground disturbing actions should be carried out carefully or avoided altogether. If you can find another way to do a repair or do something, then do so, because avoiding ground disturbing actions may streamline the timetable and the costs associated with the project, as these actions may require additional surveys and consultation processes that can take days to years to complete. Please do like, share, subscribe, and comment below to help support this channel and help me succeed so I can post more for you. Thank you all for joining me. Talk to you soon on the next one.
Definitely be sure to click on the above images to subscribe and watch more videos and really help support my channel so I can make more videos for you.